on is that the public doesn't know enough about the legal system, and that the public education you're doing is great, but vastly inadequate. Vastly inadequate. I think that the studies I've seen, and maybe these are your own studies, show that the average person feels almost totally disenfranchised from the legal and court system because they've come to feel that somehow it's weighted against them, they don't understand the language, and so forth. If public education programs can be done which truly reach the public, then I believe you can serve the profession in an exemplary way by being proactive in the court of public opinion. But, and this is the point I really want to make because, as I said earlier, I think you're agreed that public education should be done. Much of the public education that the bar has been doing is deadly dull. It, in fact, talks to us in legal terminology rather than in good, old, simple, gutsy, meaningful English. And secondly, it is often done on topics that are of concern to lawyers and not to the public. So let me urge you to set up a public education program in your county based on something that will also be very valuable to you, and that is the area of research. If the Bar Association in any county would simply do a simple public research program, a poll, if you will, but let's do it right, and ask people how they feel about the bar and what they would like to know, what would empower them and make them feel more comfortable with lawyers and the legal system, wonderful things happen. First of all, just by doing the research, you get a lot of publicity. People talk about it. They're interested. Secondly, I can tell you what people will say right now. God, that's the first time a lawyer ever asked my opinion. Not a bad kind of thing to have said out there on the streets. And the bottom line result will be that you'll be able to tailor some programs that really will reach your people. I have seen bar education functions attended by 2 people, and I've seen bar education functions attended by 2,000 people because they really were dealing with the issues. So let me urge you to do some public education, but to base it on research. When you do the research, ask some other questions that you'd like to know on public opinion about lawyers, not the big national studies, but what do they believe in your county? And what are their gut opinions, not just the facts, but their gut opinions about the courts and about lawyers? If you will do that, I think you'll get some benefit out of the research itself. Let me make another suggestion to you. At the end of this decade, we're going to have the bicentennial of the Constitution. The bicentennial of the Constitution. If ever there was a subject that lawyers have almost a public obligation to go to the people with, it's this. You've probably seen all the studies that show that sometimes a majority of the people of the United States would be willing to throw out the Bill of Rights. In fact, the Gallup organization, every 3 or 4 years, I can't remember exactly which, and I'm saying Gallup and it may be Roper, one of the polling organizations, every X years, goes on a nationwide poll and asks people how they feel about certain propositions. And what they do in this poll is they take the various sections of the Bill of Rights and frame them in accord with present-day issues. First Amendment, do you feel that the press should be able to come and pry into your business and to attack businesses and government and others? Of course, the answers are always no. The result is that sometimes as many as 70% of the public would, given a chance, throw out the Bill of Rights. Here, it seems to me, is a great opportunity for the bar to show what its mandate is, at the same time as helping the public understand the wonders of our system. Now you say, well, it's coming along the end of this decade. I won't even be a bar leader by then. My experience tells me that if you want to have a really bang-up centennial or other kind of celebration. It's not at all too early to start the planning process. Furthermore, if you get out there and let people know you're going to do it, you'll probably keep someone else from stealing the show. An item that is of great interest to many people is the one that I just mentioned, the question of the First Amendment. What are proper First Amendment rights? How does it conflict with the 6th and the 14th and with rights of privacy? Well, there's a technique that you may want to use, which is being used in many parts of the country, which for proactive public relations by a bar association is very potent. What it is to hold a local First Amendment Congress. You want to improve your media relations and your public relations at the same time. Your bar association should convene on a local basis a First Amendment Congress, and call it that. Gather people from throughout your area for a day's session on the First Amendment and talk about the real First Amendment issues. Talk about the legal aspects of them, talk about the media aspects of them, talk about the public's rights in the First Amendment. If you can get the opinion leaders in your area to come to this Congress, and you won't have much trouble because this is such a hot issue today, you will have an activity that will reflect extremely well on the bar and on your bar association, and you will be following the basic rule of public relations for an association. And that rule is make news, not news releases. And that's one point I just want to spend a minute talking on before I wrap up here. To too many organizations, particularly smaller ones, and some of you I know are in small counties, that is to say, counties with low population, and therefore smaller organizations. Too many of these organizations feel that public relations consists of sending out news releases. I hope I've done something to suggest that that isn't true by urging you to actually get into events and get out into the court of public opinion in an active way. But I want to just emphasize that point. If you can do something which makes news and the public expresses its interest because it is news, and the media, therefore, trying to please the public, expresses its interest, you will immediately be seen in a totally different light, in a totally different structure by the media and by the public. You will be seen, first of all, as a public-spirited organization. And I guess I don't have to tell you, the studies show it, that in many areas the bar and lawyers are not seen as very public-spirited. Secondly, you will get coverage for your activities. Something that the press perceives as an event, as news, they are quick to cover. And I don't have to tell you what they do with the news releases that you send out. I might just add, however, that if you're going to send news releases, and certainly you will have some of those to go when you elect officers and you're having a meeting and other routine events, please do us all a favor and see if you can keep them to like a couple of paragraphs. And see also if you can answer the following question in the affirmative before you send it out. Do I really need to send out this news release? Unless you could answer that very strongly in the affirmative, you'll do everyone a favor by simply not issuing that particular piece of paper. Well, I want to urge one more activity on you. And this is controversial, so I'll be a little careful of it. In our profession, we have come to have just a tremendous confidence and faith in the court of public opinion. Certainly, it's the only court that's higher than the Supreme Court in our country, and we all know that. But we've come to have such faith in it that we have begun to think not just in terms of rights in the court of public opinion, but also to think in terms of responsibilities in that court. Public relations professionals are, if I can borrow your word, the attorneys in the court of public opinion. Our job is to keep the communications and the feedback and the events and the opinions flowing so that the public can, in fact, exercise its judgment. But it seems to me that in a nation founded on law like ours, that the bar associations have a particularly high responsibility not to duck issues, but to take part in debate in the court of public opinion. Now, I know that's a controversial subject. Should you stand up on issues? Should you, in fact, crawl into the woodwork because your own members are probably not agreed on most issues? Well, I want to suggest a formula to you, because I believe, and obviously this is the bias of my own profession talking, but I believe that you have not only a responsibility in the court of public opinion, but a fantastic opportunity if you are willing to align yourselves with the issues of the day. Now, here's my little rule of thumb. Should there be an issue in which there is near unanimity by your bar, for heaven's sake, jump into the court of public opinion, express your beliefs strongly. In that other 99% of the issues where there isn't unanimity, and it would be a divisive thing for you to take an official position because it would probably end up being a vote of the bar leadership, which would be strongly opposed by at least a section of the bar membership. In those cases, please stop ducking the issue. Instead, start participating in the discussion by at least circulating materials that show both sides or all sides if there are more than one. Get the Bar Association out there in front of the public. It's easy to do this without taking a position, but at the same time to participate in the debate. Let two members who represent opposing views issue papers under the Bar Association's aegis showing the difficulty of this issue and that there are differing points of view. Do you see what I'm driving at? I'm urging bar associations as a group to be seen as participants in the court of public opinion. And you can do that without necessarily trying to get the public persuaded towards view A or view B. What you're doing is having a voice in the debate, helping to shape and control the debate. Because, you know, the funny thing is that in the court of public opinion, that's all any of us can do anyway. If all the lawyers were agreed on some point and tried to persuade the world, I have a hunch it would be doomed to bitter failure by the simple fact that all the lawyers agreed on it. And the rest of the public would be very, very wary. So when you analyze it, all you're doing, whether you take a point of view or whether you merely contribute to the debate, is putting forth information on which the public, the ultimate court, will make a decision. Therefore, I cannot see that staying out of debate on any issues that affect the bar is helpful to the bar. I think it turns the forum over to irresponsible, uninformed spokespersons who very often end up shaping the issues against you. I don't have to tell you what the issues are, but I can tell you from my own experience that the public wants to know where the bar stands on no-fault insurance, on plain language, on huge and well-publicized contingency fee settlements, on legal services for the poor, on lawyer advertising. You know the issues. The people also want to know why your fees are high. And in order to explain that to them, and I assume it is rationally explainable, somebody's going to have to... Maybe I got a hot one going here. Let's talk about this a minute. I believe it is explainable. In fact, I wish you'd raise them a little bit because my profession generally tends to follow you by about $4. And so if you can get them up there, please do. Isn't it funny? That's an issue nobody wants to talk about. And yet the medical profession in this country is much closer than it believes it is, according to all the opinion polls, to suffering some very severe regulation in the form of federal insurance or federal or state laws, because they will never talk about their costs, about their fees. Everybody merely knows that they're very, very high. Don't let someone else shape that issue. You, through public education, can do one of two things. You can either deal with the fact of legal costs today, or you can deal with the meaning of legal costs. And the meaning of legal costs is it a good buy? Is it a good purchase? Do I get my money's worth? Certainly you can at least deal with that, if not with the other issue. But I urge you, don't duck the issue. Because some public relations consultant that goes around doing community organizing like me might just organize a group to bring it up. And then you'll have to respond. And you know what I feel about responding. We'll make it a public relations issue. And we will get our messages across in the first 30 seconds. And theater, wow, I mean, these folks are old hands at that. Picture the scene. Picture the scene. We have an issue going. And the bar sends forth its best Philadelphia lawyer in his pinstripe to make a statement. And I send old Aunt Molly with her gray hair and her neat little pin right out of the 20s. Now, who do you think is going to come across on that issue? Well, I guess you know already who's going to come across on that issue. So I urge you, don't duck issues. Don't necessarily take positions, but do be helping to shape that debate. What's the bottom line on all of this? Why should you be doing it aside from your responsibilities and your rights in the court of public opinion? I think it's an absolute financial as well as social bottom line for the legal profession, and I think I can prove it. If the public understands that legal services are a good purchase and an essential purchase in our system, how many hours is every lawyer going to save in explanations to every client? If, in fact, the public believes that your causes are right and just, or at least causes in which they should be involved, and if you are taking a role in helping the public make those decisions, how many allies for the legal system and for legal practice can you pick up, which you do not now have in certain places? Finally,